page is?
That's on page 4.
All right, thank you. Good morning. Nine. All right, the court is calling 2025 CR 013959-02, State versus Gilbert Cuellar. Can I have parties announced for the record?
Brandon Brader for the state.
And Jonathan Alvarado for the defense.
And are you Mr. Cuellar?
That's fine.
All right, off the record for a moment. Deputy Laura, can you have them move to the other end? All right, we're back on the record. Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Are there any applications?
Or not, Judge.
All right, Mr. Cuellar, did you review the true bill of indictment with your attorney? Did you understand it?
Okay.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Judge be waiving the punishment enhancements, but otherwise proceeding as trial.
Any objections to the waivers?
No objection, Judge. Thank you.
You're welcome. Mr. Cuellar, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with deadly conduct, discharge of a firearm as a third-degree felony. Sorry, just a moment. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason that the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Cuellar, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
That's fine.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. This will run concurrent with 2019 CR 5300. Did you understand that to be your plea? Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Judge.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? I'm sorry,
No contest.
state any evidence?
Judge, you have to state exhibit number 1 and all that.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulations of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, just that he's ready to move on with his life. He is on parole for the case that's being run concurrent. And so he's going to go back to TDC and serve his time on both this case and that case, which asks you follow the plea bargain.
All right, the court is finding you guilty. The court will sentence you to 2 years in the prison. Give you credit for any time served. This was to run concurrent with 2019 CR 5300, and there's to be no residing in households with children. Did you review the document titled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so we can go off the record. Hey, if you don't change your ways, you know you're going to end up spending the rest of your life in prison or jail. You understand? All right, do better, okay? All right, good luck to you.
Thank you, Judge.
Court is calling 2025 CR 00587 State versus Jamison Franklin. Could I have parties announced?
And Jonathan Alvarado for the defense.
And are you Mr. Franklin?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision with your attorney? And did you understand it?
So, Judge, I apologize. I have not gone over the First Amendment with him, just to kind of show it to it real quick.
Okay.
This was what was on the older case.
Can you put it on like the third or something?
Yeah.
Wait, let me just check, just 1 second. Oh, I'm sorry, off the record for a moment. All right, the second is fine. Yes. And we're back on the record, Cindy. Wait, no, that's what I'm saying, but just so you have noticed it was.
Okay.
No. All right. So, Mr. Franklin, did you have a chance to review the motion to revoke community supervision and First Amendment motion to revoke community supervision with your attorney?
Yes, yes,
And did you understand it?
yes.
Are you the same Jamison Franklin who was placed on community supervision for the offense of manufacturing delivery of a controlled substance, penalty group 1, 4 to 200 grams on July 24th, 2025 for a term of 8 years? Is that you?
Yes.
All right, state.
On state's first amended violated condition number 1 on or about the 3rd day of December 2025 in Bear County, Texas, the defendant Jamison Robert Franklin committed the offense of possession of controlled substance or violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violated.
Well, I mean, if he's pleading not true, today is supposed to be set for a contested. Are you all?
So,
Do you want to?
I apologize, Judge. I didn't know exactly what the court wanted to do today because this is actually a First Amendment we were just handed today. These are new offenses that happened. I think the offense date is on either Monday or Tuesday of this week. And so I was going to ask the court for a reset at this point because of the new allegations. Additionally, Judge, I was not appointed onto the new cases. So I do not have the discovery as of yet.
So from the allegation, that's not the amended motion, but the original motion, the allegation of possession dated from December 3rd, 2025, you don't have discovery on that?
No, Judge, I do have discovery on that. I am the attorney appointed on that case. I would just ask for a reset, Judge, because at this point with the new offenses, I think it would be, for all parties and the court, it might not be efficient to try and proceed with those cases, the MTR today, when potentially we could wrap all the cases together. And I've conferred with the state on this, and that was kind of our approach to it, Judge.
So when is that going to be accomplished, if that is accomplished?
Well, I would need to get on the new cases or get the discovery in the new cases. So as soon as that could be done, Judge,
And are the labs in for the,
So, no, Judge, and the types of charges that the new cases are, we would not be able to proceed on the drug at this time because the turnaround for the testing, but there are two other cases that would potentially be able to be proceeding on.
all right, and the other two cases,
It's a theft and a fraud use.
do you have discovery on those?
I do not.
All right, so he needs to have discovery on those. And Norma? Yes. This will be the last reset for this case. Set this for a contested hearing in 3 weeks.
And just, for opinion, is Roger Bettis, so I'll contact Roger Bettis and see if I can just put Jonathan on there.
Okay.
And just take him off.
Thank you.
They're assigned to.
That works. Thank you.
I didn't assign. I just.
Yeah.
3 weeks, Judge.
Yes.
That would be March 19th.
March 19th? Okay.
Okay. Thank you, Judge.
You're welcome.
Sorry for the confusion.
Oh, no problem.
Yeah. Well. I'll get back to you on that. So, is this okay? I don't know. We don't really go over it once more. Yes, sir.
Okay. All right, you want to step back? Go over things?
I'm sorry. So you want to talk to me further about signing this, or you want to talk to the judge about the next part of you? I would like to talk to Mrs. Boyd about the next part. Okay.
Okay, talk to me concerning what?
The certification of right of appeal, we're gonna ask for a contested motion to revoke.
Mhm.
My client understands he's gonna plead not true to the allegation, one of the allegations. But it's about signing the trial court certification of right of appeal. I've circled, it's not a plea bargaining case. He still does have.
Here's the thing. I would love for attorneys not to check boxes because I decide whether he can appeal or not. And I don't know what I will do in this case. And I don't know if y'all have reached an agreement whether or not he would waive his right to appeal. So I'm in charge of checking boxes. So if y'all could tell attorneys on trial court certification, please do not check boxes because then I have to scratch things out. So now, with regards to the motion to revoke, this is what I'm going to explain to you. This is a contract with the court. If you want a contested hearing, what that means is the state, whatever allegations they're saying that you did or whatever rules they're saying you violated, they'll have to bring in witnesses to prove it. Do you understand?
Yes, sir.
All right. So do you want a contested hearing?
For the harassment allegations, yes, ma'am.
All right. So the only thing that I have in the,
Trespass, apologies.
yeah, the only thing I have in the motion to revoke is an allegation that you committed a criminal trespass and the use of marijuana. Those are the only two things I have.
Yes, ma'am.
Okay.
Excuse me, Ms. Roy, is it possible to only contest one of those?
That can be up to your attorney if that's what you want to do. Yes, you can plead true or not true to whichever allegations you want to plead true to.
Yes, ma'am.
All right. So let me ask you all this.
Yes, sure.
What is the plans for, what is the recommendation?
Recommendation from the states to revoke the law.
All right. And so I only have two allegations, criminal trespass
Well,
and marijuana.
there's gonna be an amended one coming. I need to be in completion because there's gonna be two number ones added to the MTR for the cities.
All right. And in the amended allegations, what are the allegations?
Two charges of harassment.
Okay. So then what we'll need to do is number one, is that going to be filed today?
But I need supervision as soon as I can tell you so they can, there and get the amended.
All right. So they're telling me that they're going to amend the motion to revoke. So what that means is they're saying they're going to add more allegations other than the criminal trespass and the marijuana. They're telling me they're going to add 2 allegations of harassment. I don't know anything about these allegations. I won't know until somebody presents some evidence to me if they do so. But in regards to motions to revoke, you can plead true or not true to any allegation you want to. So that means you don't have to plead true to everything. You don't have to plead not true to everything. It's really up to you, hopefully after the discussion with your attorney. All right, so what I'm going to do, I'm going to reset it. And I'm going to reset it. It's going to be reset for a contested. If it turns out you've spoken to your attorney and you decide not to contest, your attorney, I'm going to ask that you let probation know because they'll have to have witnesses here. And does everyone want the witnesses in person?
Yes, sir.
All right. So, Ms. Ferguson, can you set this for a contested hearing? And what we'll set it for? We'll set it in 3 weeks. And so that'll give your attorney 10 days, well, more than 10 days.
March 19th.
Yes.
All right, so March 19th is going to be your contested hearing.
Yes, Judge Boyd, while I have you, can I ask a question?
Sure. Now, whether I'm allowed to answer that or not depends on what the question is.
If I wasn't informed that further contact would lead to harassment, are those amendments to?
Okay, so this is what I'm going to tell you. Because you're asking me about the allegations in the motion,
Yes.
I'm not allowed to give you the law on that.
Okay.
You have to speak to your attorney because once I start commenting, because it sounds like you're trying to raise some sort of defense to me. And if no, the question you're actually asking me is sort of a defense. And that's, if I answer your question, I'll be commenting on the evidence and that makes make it seem like I'm not being objective and open. So that's a question you'll have to ask your attorney. So any legal questions of that nature, be sure to talk to your attorney about it and he'll give you the law on it, okay? All right, any other questions?
No, thank you, Judge Boyd.
You're welcome. So we'll see you back on March 19th. That'll be a contested hearing. If you discuss things with your attorney and you decide not to have a contested hearing, he'll let probation know so they don't have witnesses. Okay?
Love your flowers.
Oh, thank you.
Yes, ma'am.
They brighten the room. I think so. $20. All right, the court is calling 2026 CR 0000978 State versus Jessica Cantu. Could I have parties announced for the record?
State?
David Rodriguez for the defendant.
And are you Ms. Cantu?
Yes, ma'am.
Sorry, Odyssey is being very finicky today.
You have to do an update on it, just.
Yeah. And there are no applications in this case?
There you go.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Cantu, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State proceeding on the indictment as presented?
No, Your Honor, state used to waive the punishment.
Any objection?
No objection, Your Honor.
Ms. Cantu, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, yes, okay, yes.
All right. And when I say the plea bargain page, that's just the page that tells you what you've agreed to. So do you understand what you've agreed to?
Yes.
All right, according to your plea bargain agreement, the state is waiving the enhancement. They're asking that you be punished to 1 year in the Bear County Jail under 1244, and there's an $800 fine and no applications. Did you understand that to be your plea?
Yes, could I ask you for a favor? Is there any way that I could referral, same parole?
I'm sorry, what?
A referral from referral, because they're asking me to take something from the court or from the.
So what will end up happening, when you're at the Bear County Jail, at the jail, they have different organizations there, and they will do the referral for you for Haven for Hope.
Okay,
I personally can't do that because if I accept this plea, you'll no longer be under my jurisdiction.
is that
But I
the-
will tell you this, when you're released from jail,
Yes.
if for some reason you don't get to the referral and you can't get there, if I'm still here, you come back here, then I'll be able to pick up the phone, okay?
Okay, yes, thank you so much.
You're welcome. So everyone, is that the plea?
Yes.
Yes.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes,
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes, ma'am.
Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
That's my first.
State any evidence to support the defendant's plea?
I'm sorry, yes, ma'am. State offer seats, the other one or not.
Any objection?
No objection.
All right, off the record for a moment. Norma,
Yes, ma'am.
can you call Esperanza Court and see if they have anyone who can come over and give her some resources
Yes.
to help her get into Haven for Hope, or either call the community court? We'll see what we can do today, okay?
Yes, thank you.
Thank you, Judge.
All right, state, you may be excused. Did you review the waiver and consent to stipulation of testimony with your attorney? Did you understand it and
Yes.
sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of the client?
Only that we urge the court to follow our plea bargaining agreement.
All right, the court will follow your agreement. The court will sentence you to 1 year in the Bear County Jail under 1244, give you credit for any time served. There's an $800 fine. Time and money will run concurrently. Now, with regards to the 1 year in the Bear County Jail, I'm not in charge of whether the jail counts every day that you spend at the jail, 2 days for every 1 day spent. That's completely up to them. The only thing you're receiving from me is a sentence of 1 year in the Bear County Jail. So you will not spend longer than a year. You should not, okay? All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney.
Yes, ma'am.
Okay, so deputies, if you could let her remain in the courtroom, I'm gonna see if I can get someone to come over from the treatment courts to help her out. All right, thank you.
Thank you, Judge.
Oh, the name of that place is
Wait a minute.
Wakayama or Wamayaka?
Oh, gosh, there's so many cities that are so close to that.
Wamayaka, I think that's what it is.
Not Yokohama.
No. Let's see. Okay. Wakayama, Wakayama. Oh, that's where that lady says she teaches. And she bought a home there and now she teaches, but she speaks the language fluently.
And she actually moved there permanently and bought a
Yeah,
house. and
she's from
everything.
Australia though. I think Australian or either New Zealand.
Okay, so kind of funny. One of my coworkers was an Aussie, and I had a British coworker also, and students absolutely could not tell the difference between our accents. And I was like, "You think the Aussie and I sound the same?" Yeah, pretty much.
Aussie, oi, oi.
But as they pointed out, it's like, well, look, the Tokyo and Osaka accents are really different, and it's like, I bet you could not hear the difference. Like, that is fair. It's like, no, there's no way I could hear the difference.
Oh, wow.
So,
All right, everyone, the court's gonna go.
Across this final courtroom session, two very different moments define the day. One rooted in accountability with compassion, the other in firm procedural authority. In the case of Jessica Cantu, the court finalized a plea agreement for possession of a controlled substance under 1 gram. The judge imposed a 1-year sentence in the Bexar County Jail under 1244, along with an $800 fine, making it clear that jail credit calculations were up to the facility, not the court. What elevated this moment beyond routine sentencing was what happened after. Even though jurisdiction would end once the plea was accepted, the judge paused proceedings and instructed staff to contact treatment courts and community resources to help Cantu connect with Haven for Hope. It was a striking balance, the law was enforced, the sentence was firm, yet the human element was not ignored. The message was clear, consequences matter, but so does opportunity for rehabilitation. Moments later, the tone shifted in the case of Joseph Dominguez. His plea deadline had arrived and negotiations had collapsed. When defense counsel announced they were at an impasse and heading to trial, the judge responded decisively. A 3-day jury trial was set for May 12, and the court made it unmistakably clear the plea deadline had expired and no plea bargains would be considered without good cause. That single declaration changed the trajectory of the case. What could have been negotiated behind closed doors would now unfold before a jury. Together, these moments show the dual reality of criminal court, structured deadlines, strict procedural boundaries, and finality on one hand, and on the other, a judge willing to make an extra call to help someone find treatment before walking out the door. Courtrooms are not just about verdicts, they are about timing, leverage, and sometimes grace under pressure.